Hello everyone, we welcome you back to our channel. This is Legal Mindset at the back, and today we are going in for family law 1. So we are going to look at a separation agreement. We shall first of all define what is separation by agreement. We shall go on to look at the contents of a separation agreement, and as a bonus I will take you through the fundamental legal principles that govern a separation agreement. So, to dive into it, I beg you to subscribe such that we continue. Okay, now, separation by agreement. It is also known as mutual separation. So, in mutual separation or separation by agreement is where the husband and wife agree to stay apart or to stay away from each other for some time. By doing that, they have to put that either in writing or in words. That's the separation agreement. But for the separation agreement to be binding, it should be put in writing. It should be express. So, a separation agreement is an agreement where a husband and wife agree to stay apart for a given period of time, after which they may either get back or go for divorce. Be very clear on this. When a separation agreement is initiated, you are either looking for redress to sort yourselves and come back, or to go for divorce when you get the grounds for divorce. Because separation usually comes when the grounds for divorce are absent. So, let us now look at the contents of the separation agreement. Because by this type of separation, mutual separation or separation by agreement, you should look at the terms or clauses or contents of the separation agreement. And number 1, we shall look at the parties to the agreement. The separation agreement should stipulate what are the parties to the agreement: the man and the wife, their age, their nationality, all the information about the parties should be included on that clause of parties to the agreement. Then there is the clause of living apart. Each of the parties should agree to live away from each other. Maybe you have one house, you say, the man shall use the boys' quarters, I shall use the main house as the woman. Maybe you say the man shall leave and go somewhere else, the woman shall stay at home. The clause of living apart. We can look at another clause, the time, the clause of time. This one stipulates the duration of the agreement. You can say our separation shall take 2 years, it shall take 3 months. That is the time clause. Now, let us look at the property clause. In the property clause, it stipulates how you're going to use the property you have jointly. So, for example, you have rentals. You own them with your wife. They are in Kabalagala, others are in Kansanga. You say, you will collect rent from the rentals of Kansanga. The man will collect rent from the rentals of Kabalagala. That is the property clause. You put in place how are you going to use the joint properties you have. So, let us look at another content of the separation agreement, the non-molestation clause. This one is a bit technical, and I beg you to be very keen with it. The non-molestation clause suggests that no party should molest against the other. So, what is molestation? Because we have said the non-molestation clause. The Black's Law Dictionary 7th edition at page 601 defines molestation as the persecution or harassment of a person. To molest means to harass, to intimidate, to cause fear. That's why we say non-molestation clause. None of the parties shall intimidate another during the time of the separation agreement. You should not provoke one another. So, Non-molestation is a legal order that prohibits a person from harassing, intimidating, threatening, using violence to another person, especially in family law. And that definition I've just said was used in Bromley's family law book. So, in the case of Rosette Tabitha Nakiryo Wamabike versus Michael Mabike, it is divorce cause number 68 of 2020. In that case, Lady Justice Jane Rwakoko came in to simplify for us what the non-molestation clause means. So, she relied and cited Section 4, subsection 1 of the Family Act of UK, Cap 27, which provides for the meaning of non-molestation to mean an order that prohibits a person from molesting against their spouse, harassing and mistreating them. She also relied on the Blackstone Dictionary 70th edition to define molestation to mean the persecution or harassing of someone. So let us look at the purpose of the non-molestation clause in the separation agreement. The non-molestation clause prohibits violence, as we have seen. It puts a gap and stops the spouses from intimidating one another. It prohibits domestic violence. It prevents emotional abuse. It protects children from exposure to family language or conflicts, because it is saying, do not intimidate, do not threaten one another. It also supports compliance of the terms of the agreement. If you respect the non-molestation clause, you're respecting the agreement because you're not intimidating one another. Now let us go to a very key and also sacrosanct term of the separation agreement, the Doncaster clause. So the Doncaster clause is also technical because it determines a lot of things in the period of separation. The Doncaster clause is in effect that none of the parties to the agreement shall have liberty to have sex in and outside the marriage. Here is a very simple way of saying it. The Doncaster clause means that if you have put 2 years of separation, it means you're going to live without sex for 2 years. If you go for sex with another party, you're committing adultery, a ground for divorce. Even you should not have sex with your partner whom you're bound with in the separation agreement, because if you do so, you have terminated the separation agreement. So the Doncaster clause also, we call it chasing. You should not chase. You should not have sex. So the Doncaster clause also determines the validity of alimony given to the woman. If a man is giving alimony to the woman and she has sex outside marriage, then she has lost her right to alimony. Alimony is like that support the man gives to the wife during the separation. So, in the case of Fearing versus Ileford, a case of 1884, court held that such a clause will not be implied if it is not expressly included. If you do not write it down in the separation agreement, it shall not be binding, it shall not be implied. And if committed, the whole agreement will be contrary to public policy. The whole agreement will be void. Now let us go to another clause, the custody of children. In the clause of custody of children, the agreement should put in place who of the parties will have custody of children. Custody of children is not a mandate that it shall follow the mother. No. Who told you that it has to follow the mother? I'm going to give you a very interesting judgment of Justice Benjamin Odoki. on the custody of children. In the case of Lucas Barry versus Florence Choncho, divorce cause number 011 of 2008. And in that case, court based on evidence that the respondent was not fit person to have custody of children, basing on her conduct. Her conduct was bad, and her cult beliefs, she had acquired new cult beliefs which were not fit for children. And court relied on that to give the custody of the children to the man. Justice Benjamin Odoki, as he then was, went on to state that the welfare in the relationship of custody of children should put in account all the circumstances that will affect the well-being and upbringing of children. So, and the court has to do like a wise man, acting for the interest of children. Court shall not give custody of children to a careless woman, to a careless man. It shall choose the most fit person. You can also talk about the amendment clause. That one will stipulate if you forgot something, you can come in and add it. Those are the contents of the separation agreement. Thank you very much for watching Legal Mindset at the Bar. Subscribe.